Call this meeting to order. Happy Monday. Welcome to meeting number 18 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of October 1, 2025, the committee is meeting to continue its clause-by-clause study of Bill C-9, an act to amend the Criminal Code, hate propaganda, hate crime, and access to religious or cultural places. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to confirm that sound tests were made successfully. Before we continue, I would ask that all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including and especially the interpreters. You will also notice a QR code on the card which links to a short awareness video. A few comments for the benefits of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. For those on Zoom, at the bottom of your screen, you know how to do the translation. And a reminder, all comments should be made through the chair, please. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. And I would like to welcome our witnesses once more and thank them for their ongoing and continued patience. From the Department of Justice, we have Kristen Ali, Manager and Senior Counsel, Criminal Law Policy Section, Joanna Wells, Team Lead and Senior Counsel, Criminal Law Policy Section, and Marianne Breeze, Counsel, Criminal Law Policy Section. We are still debating Mr. Brock's sub-amendment to CPC 8.1, and this is where we were when we adjourned this last meeting, so we will pick up where we left off. And where's the speaking list here?
So you adjourned, so I think we have a new speakers list to establish.
You're quite right, okay.
Yeah.
So Mr. Brock, you've got your hand up.
Monsieur le Président, juste
Mr. Fortin, hold on.
Avant qu'on débute, je vous ai pas.
Before we start, maybe I'm mistaken, but I didn't hear you say something. I didn't hear you say this, unless I'm mistaken. Were sound tests done, and are they conclusive? That's my question.
They were done and they were conclusive, yeah. I witnessed it myself.
Président.
Okay, no, my pleasure. Okay, so hands up again. I saw Mr. Brock. Mr. Fortin, do you have your hand up on that issue only, or did you want to speak?
No, it was only on that. Seulement sur.
Okay, so I'll just go in order here. Mr. Brock, Mr. Baber, and then Mr. Lawton. Okay, Mr. Brock, you have the floor.
Thank you. Thank you, Chair. Welcome back, colleagues. There was a general discussion before we left the House and engaged in a constituency week that there would be some consideration to a new amendment that clarified the language, ideally trying to reach an agreement of the impasse that we had before Christmas regarding the removal of the religious defense in the criminal code. I understand there was some consultations with stakeholders by the government in that regard. I received proposed language late yesterday evening. I've had a brief opportunity to explore that language with my team and get instructions. I also had an opportunity of speaking this morning with the minister himself, and it's my understanding that someone from the Liberal team will be moving this particular amendment to start off our discussions today. So I simply want to put that on record, as I anticipate this will give every member at committee an opportunity to express their opinion on this religious defense.
Thank you, Mr. Brock. Mr. Bauer?
Yeah, I think the Conservatives have been very clear that we are of the view that elimination of the religious defense to willful promotion of hatred is something that we cannot support. there were some good faith discussions about looking to insert another amendment. I point to the fact that we have Mr. Lawton's amendment still on the floor that attempts to deal with that. So I don't know. I would perhaps leave it to your judgment, or maybe with the assistance of the clerk, to see how we can potentially deal with a further proposed Liberal amendment should the government be in position to present it.
Mr. Lawton?
Yeah, just to be more explicit here, and I want to respect, obviously, the privilege at issue here, but if the Liberal team and the Liberal government are serious about dealing with these concerns that have been raised about religious freedom and freedom of expression, I think it is important that that's put on record. So I would seek unanimous consent from the committee to allow to deal with, if someone is willing to move it, the addition of clause 11.1. And to put that as the issue at hand, and then once that's dispensed with, continue on. So I'd be seeking unanimous consent for that.
So I understand you're seeking unanimous consent to do something if they do it?
Well, I'm seeking unanimous consent to permit any member who wishes to move that amendment to do it at this point in our deliberation on Bill C-9. This is something that is consistent with what the minister, I believe, has communicated to Mr. Brock.
Okay, thank you. There's nothing to vote on in this circumstance, so is there anything else then, Mr. Lawton?
Well, I'll add myself back to the speaking list, but
Sure.
Seeing as no one said no, is anyone prepared to move this amendment that deals with religious freedom concerns?
There's a speaking order, and if somebody gets to their turn and they want to move something, we'll deal with it when the time comes. But for the time being, unless you're moving something, I understand, and we'll get to Mr. Housefather. I'm simply asking if you're done.
Well, yeah, but I'm seeking unanimous consent, so that's
Seeking unanimous consent for.
that 11.1 can be moved at this point.
Okay, thank you. Do you mind if I go to Mr. Housefather
Absolutely.
first? Because I suspect he'll address this. Thank you, Mr. Housefather.
Thank you, Mr. Chair. And yes, we do have an amendment that we will be moving at the proper time when we get to the clause at hand, which is on page 6, line 12, and it's well after clause 4 that we're now in. We've been dealing with, the current sub-amendment to an amendment on the floor for quite a long time, and I think we should dispose of that before and go through the other clauses to get to where we would be to put forward a for greater certainty clause that has been discussed. While I believe a lot of the arguments the Conservatives have been putting forward have been incredibly misleading to people, we do have to deal with the concerns that have now been raised as a result, and this for greater certainty clause, I think, will help do that. But again, we had earlier times, Mr. Chair, where I, for example, had an amendment that I had wanted to propose and then park, and we weren't able to do it because it was in the middle of a clause. And right now we're in the middle of a clause. So I would prefer at least to deal with the current sub-amendment and amendment that we've been dealing with ad nauseum, vote on them. If the Conservatives are finished talking about them, we can just vote, and then we can move to our for greater certainty clause. Thank you, Mr. Chair.
Thanks, Mr. Housefather. Mr. Lawton, back to you.
So I appreciate that. I think first off, there are a couple of concerns. Number one, the Liberal government has been communicating to Canadians, to the media, to people who are concerned about some of these core religious freedom and freedom of expression issues, that they intend to address it through an amendment. The reason that we have been parked for so long on the current discussion, which is Mr. Brock's sub-amendment to my amendment, which attempted to provide some clarifying language in light of the BQ3, I believe, the amendment that was passed last year, removing the religious defense. The amendment that we are currently dealing with, or the sub-amendment, would be arguably unnecessary if we had a strong protection at another point in the criminal code and in Bill C-9. So I think if the Liberals are actually intending on dealing with these religious freedom concerns, the passage of their amendment would actually render much of what we're discussing here moot. So I'm trying to find ways that we can collaborate and break this logjam up. If the Liberals are willing to move this amendment now, as we've been told by the minister they are, it would actually make more sense to deal with it right now, to deal with out of order, because that will have a bearing on how other issues that arise in this bill are dealt with, in particular, the very sub-amendment that we're on right now. So if the Liberals aren't prepared to move this, I think that speaks volumes about how they're actually prioritizing addressing these concerns. But that would be what I'd say to Mr. Housefather's point, is that, there's arguably a line conflict between 11.1 and what we're discussing right now. And I want to make sure that we're dealing with the strongest possible protections here. And I don't want us to dispense with something now under the promise that we'll get to this later on, only to find out that it's not going to be allowed, it's going to be ruled out of scope, or there's going to be a line conflict found there. So I'd like to be re-added to the bottom of the speakers list, but that's my intervention right now, Chair.
Thank you, Mr. Lott. Mr. Brock's next, but Mr. Housefather, did you put your hand back up, or is that still up from before? You did, okay. All right, so Mr. Brock, Mr. Baber, and then Mr. Housefather.
Thank you, Mr. Chair, and I appreciate Mr. Housefather's comments. I deem it to be a little at odds with the spirit of the discussions I had, not only with the minister himself today, but also with the parliamentary secretary this past Friday. The only thing that I can conclude from that is they're just not serious in terms of dealing with this particular amendment and ending this logjam that we have at committee. I'm also mindful of the comments that I put on record before we finalized line by line, clause by clause on C-14. And I reminded this committee, as I reminded Canadians as a whole, that there was a very strong message from this Liberal government, particularly from Prime Minister Carney and House Leader Stephen McKinnon, that, in quoting Mr. McKinnon's words, put up or shut up in terms of passing immediately 14 and 16. Despite the ambiguous language by the Prime Minister last Thursday in Surrey to suggest that somehow C-14 is still being held up is completely untrue. It's in the Senate, has been in the Senate for some time now. But he does want to prioritize C-16. Stakeholders have asked parliamentarians to prioritize C-16. So that being said, I'm willing to move a motion at this point, Mr. Chair, that the committee immediately prioritize the consideration of Bill C-16, the Protecting Victims Act.
That's dilatory, right? Thank you, Mr. Brock. It's a dilatory motion, so we'll vote on that. Mr. Clerk. Sorry, Mr. Fortin.
Pouvez-vous répéter?
Could you please repeat the text of the motion?
That the committee immediately prioritize the consideration of Bill C-16, the Protecting Victims Act.
You okay, Mr. Fortin? That's clear? Okay, all right, thank you. All right, Mr. Clerk.
Okay, merci. Thank you, Mr. Chair. We go to Madame Sudds.
No.
Mr. Housefather.
No.
Madame Dillon.
No.
Mr. Chang.
No.
Mr. Brock.
Yes.
Mr. Baber.
Yes.
Madame Borelli.
Yes.
Mr. Lawton.
Yes.
Mr. Fortin.
Non.
Defeated.
Okay, motion defeated. Mr. Baber.
I'm a little perplexed by what's transpiring right now. Everyone agrees that there are concerns on the Conservative side with respect to the amendment adopted by this committee, removing the religious defense as a defense to an allegation, a good faith religious speech defense to an allegation of willful promotion of hatred. After some time, our Liberal colleagues understood that this is a material concern, perhaps not just by the Conservative Party of Canada, but by many other Canadians. And so we now understand that the Liberals are about to propose their own amendment seeking to fortify some of the protections that were available under Section 319 subsequent to the removal of the defense. That is what I believe Mr. Lawton's amendment also seeks to do. So I think everyone agrees, and everyone should agree, that everyone now agrees that we want to see if we can perhaps improve the language that will be agreeable by everyone. So I'm not exactly sure why my friend Mr. Housefather opposes our suggestion to prioritize the Liberal proposal, see if we can work it out, see if we can negotiate the language. I might even suggest that we might want to consider adjournment so we can look at the collective language being proposed and compare that language to Mr. Lawton's language, understand the position of our block committee member to see if we can negotiate the gridlock that we find ourselves in. So I know that Mr. Housefather is scheduled to speak after me, and I'm wondering in good faith why we can't prioritize the proposed, this Liberal, without breaching any privilege, but the intended Liberal amendment to try and bridge the gap between the Liberal Party and Mr. Lawton's sub-amendment that we're currently debating, since they intend to do the same thing.
Thank you. Mr. Housefather.
Okay, Mr. Chair. Part of the issue is, unfortunately, with the train being canceled today at the last minute, I am not in the room, so I'm unable to have the conversations directly with my Conservative colleagues. But the proposal that we're putting forward is in a different clause. It's not a conflict of lines. But I understand the position of the Conservatives that have been filibustering on this issue for a while. In the event, Mr. Chair, that the Conservatives are prepared to stop filibustering and want to park this amendment where we are right now, move to the new Liberal amendment, which would be on line 12 on page 6. I am prepared to do that. Si le bloc est d'accord aussi, je suis prêt à le faire.
I'm ready to do that as well.
I hope then that will be treated with due consideration, and that there would then be an understanding that we would revert right back to clause 4 right afterwards. So, Mr. Chair, if I have unanimous consent of the committee to move to the Liberal amendment, which would be adding after line 12 on page 6 some language, I am happy to do that.
Are you seeking unanimous consent, just to be clear?
I thought, yes, I am seeking unanimous consent to park the current amendment and sub-amendment and to move to a different Liberal amendment that would be in a standalone clause after line 12 on page 6.
Mr. Fortin, sorry. You were gonna...
Je préciserai seulement,
Line 12, page 6, in the English version, in the French version is after line 13.
Do we have unanimous consent? Yes. It appears we do. Okay. All right. So I believe that. Does everybody have a copy of this thing? I don't think so. Let's suspend. Let's suspend for a moment to make sure everybody has a working copy of what we're about to do.
I was ready to send it.
Mr. Housefather, you had just proposed this procedure, but I don't think we actually had the amendment read into the record, so maybe you or Ms. Latanzio is here now. Maybe she wants to read it in, so it's everybody. I think everybody's received a hard copy, or at least by email, but if you could read it in, Ms. Latanzio, that might help.
Thank you, Mr. Chair. Can I go?
Please.
Thank you. Good morning, colleagues. So I would like to read into the record the amendment that was just, I understand, passed by the clerk, and it reads as follows. That Bill C9, amended by adding after line 12 on page 6, the following. Clarification clause, hate propaganda. 11.1, subparagraph 1, for greater certainty, nothing in subsection 319(2) or 2.2 of the Criminal Code shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate. If they do not willfully promote hatred against an identifiable group by communicating the statement. 2. For greater certainty, nothing in subsection 319(2.1) of the Criminal Code shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate, if they do not willfully promote anti-Semitism by condoning, denying, or downplaying the Holocaust. Mr. Chair, I just want to give a bit of context with regards to this clause. We've heard concern from faith communities over the course of the past few months, legal experts and civil society, about the removal of the former religious exemption in the Criminal Code. Those concerns were raised sincerely, and it is important to address them clearly so there is no confusion about what this bill does or does not do. Let me be clear about the effect of this change. Removing that subsection does not expand the hate propaganda offense, does not lower the threshold, and does not change the elements that the Crown must prove. The existing subsection created interpretive ambiguity that allowed the provision to be invoked in ways Parliament never intended, and its removal reflects Parliament's confidence that the existing high threshold, including the requirement that the accused willfully promote hatred, is sufficient on its own, and that the Charter protection provide the backdrop for any remaining uncertainty. Freedom of religion, Mr. Chair, and freedom of expression in Canada remain fully protected by the Charter. This is not changing. Canadians are free to hold and express their religious beliefs, and courts have been clear for decades that ordinary religious expression does not meet the legal test for willfully promoting hatred. Preaching, teaching one's faith, reading a scripture, sermons, prayer, religious education, and the good faith discussion of religious texts are not criminalized by this bill, and they have never been. The purpose of removing the former subsection was to eliminate confusion and ensure that the law is applied as Parliament had intended. The existing elements of the offense, together with the Charter protection, already provide a clear and effective framework to distinguish between protected expression and criminal hate propaganda. At the same time, over the past number of months, Minister Fraser and I met with faith leaders and religious organizations from across the country. We heard that even where the operative legal threshold was not changing, the removal of the subsection could be misread as a signal that ordinary religious expression was now at risk. And we listened to those concerns. That is why we are adding a clause for greater certainty. This clause does not create a new defense, does not reintroduce the removed provision, and does not narrow or broaden the offense. Its purpose is to make explicit in the legislation what the courts have long recognized, that genuine religious, academic, political, or other good faith discussion on matters of public interest is not what this offense targets, unless, of course, someone is willfully promoting hatred against an identifiable group. For greater clarity, the bill will state in plain terms that nothing in this legislation affects worship, sermons, prayer, religious education, peaceful debate, or even the good faith of reading and discussion of religious texts. The law continues to focus on deliberate and serious hate while protecting the freedoms Canadians expect in a free and democratic society. Ultimately, this bill is about protecting Canadians, including people of faith, from hate and intimidation. The clarifying language we are introducing this morning ensures that Parliament's intent is clear, both in the text of the law and on the parliamentary record. And with that, Mr. Chair, I move to table my amendments.
Thank you, Ms. Latanzio. Mr. Lawton is the next speaker on the list.
So just before I begin, are you confirming that the amendment is in scope and in order? Is that a firm ruling you're making?
Yes.
Okay. So I appreciate the recognition by my Liberal colleague that there is a problem with Bill C-9. And I appreciate that there has been some effort, even nominally, to engage with faith communities who have felt very targeted, very personally targeted by what's become of Bill C-9. And the problem, though, and we heard this in Ms. Latanzio's remarks there, is that this amendment does not actually seek to bolster any protections. It doesn't seek to, in her words, reintroduce any defense, any protection for religious freedom or public interest expression. It simply aims to say that none of this was at issue in the first place. So for people that were raising concerns that Bill C-9 was eroding long-standing protections in criminal law, the government's own admission right now about this amendment is that nothing is changing. They're trying to pacify concerns without actually strengthening these protections in law. And I'm very aware of the timing right now. We had a few days ago a ruling by the British Columbia Human Rights Tribunal that invoked some of the very same ideas that are at issue in Bill C-9, which was how courts and administrative bodies deal with the question of hate, and how that definition, a definition which is changing and weakening under Bill C-9, is applied to people who are engaging in discussion that may be hurtful or offensive to people, and rightly so, but still deals with contentious social discussions where people have a range of political opinions, a range of religious perspectives and views. And this amendment is coming after what the Liberals claim is consultation with faith communities. Now, I engaged in a great deal of consultation with these people as well. I actually took a bit of time over our winter recess, and I traveled from British Columbia to Newfoundland, holding roundtables with faith leaders, meeting with groups ranging from Jewish groups to Christian groups to Muslim groups to Sikh and Hindu groups. And a few things emerged from those discussions. One of them is how little those groups felt they had been consulted on these questions, and how much they felt their initial concerns that religious freedom was being infringed or affected by Bill C-9, how little they felt the government was actually taking that seriously. So something changed around the time we were getting ready to come back, and we did hear, again, to the minister's credit, that he and his office had some conversations with some groups. And these groups said that this religious defense was important not just to pacify them, but because it actually spells out in law this idea, which the courts have long viewed as essential to even upholding the existence of hate speech laws, the existence of Section 319 of the Criminal Code. And the idea that was put forward there was that the religious defense is crucial, given that the Charter specifically enumerates religious freedom. And I note that when the proposed amendment from the Bloc Québécois, which the Liberals endorsed, to remove the religious defense was put forward, the argument wasn't that it was redundant. The argument was that we didn't want to protect religious speech. If the redundancy approach were really at issue here, then the amendment would have removed the public interest defense, it would have removed the truth defense, it would have removed the religious defense, it would have removed all defenses, because what the Liberals were saying is that these defenses don't really matter because the Charter has robust protections already. So already there was a doublespeak that we heard in terms of which group was being communicated which message. On one hand, stakeholders in Quebec notably were being told that, yes, we don't agree that religion should give you a pass on violent rhetoric. We heard the Adil Charkawi case come up, a case which has nothing to do with the religious defense because, A, prosecutors did not rely on it to not charge, and B, it does not apply to any of the offenses dealing with violence or threats to violence or even incitement. It only applies very narrowly to willful promotion of hate. And then on the other hand, we have faith groups and faith leaders being told by the government, absolutely, we're going to protect your religious freedom. Nothing will change from the status quo right now. So which is it? Is the removal of the defense redundant, or is the removal of the defense important? This is not a position that right now has been reconciled. And no community is being protected from hate if their sincerely held religious beliefs and scriptures are going to subject them to prosecution. And this is not a conspiracy theory that's emanating from some distorted interpretation in, that's drummed up on X. This is something that was inflamed by your predecessor, Mr. Chair, Mark Miller, who's now the minister responsible for Canadian identity and culture, that said there is such clear hatred in 3 books of the Bible and 2 books of the Torah that prosecutors should have the discretion to lay charges inherently because you could not cite those scriptures, which he disapproves of, in good faith. So this is why Canadians have been concerned. And I would note that Minister Miller's comments were actually saying that even with the religious defense, you should be criminally charged for quoting these verses, which he did not enumerate in the Torah and the Bible, because you could not be doing it in good faith. Now, in the amendment that was just moved by Ms. Latanzio, there is no delineation of good faith because there, in fact, is no protection. There's no protection given. We're just being told that, don't worry, we're not going to erode your religious freedoms. And the reasoning is very circular. We're talking about the criminal charge of willfully promoting hate. The bill says, or the amendment rather says, for greater certainty, nothing in subsection 319.2 or 2.2 of the Criminal Code shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate, if they do not willfully promote hatred against an identifiable group by communicating the statement. So this says, for greater certainty, you are not prohibited under willfully promoting hate by doing something unless you are willfully promoting hate. That is not a clarifying statement. That is not providing any clarity or certainty. That is circular reasoning at best. The whole point of the religious defense is that it actually set out what can be conceived as hate. And the religious defense before, and also the public interest defense, the defense of truth, which I believe, and I would have to get clarity from our departmental officials and will in a moment, I believe those defenses are potentially threatened by the addition of this new clause, and I'd like some clarity on that. But before, it said that you could not be willfully promoting hate if you were expressing in good faith a religious sentiment or citing a religious text. This says you will not be engaged in the law views as willfully promoting hate if you're doing this unless you are willfully promoting hate. So it provides no definition, it provides no clarity, and it provides no limitation on how the term hate will be applied and interpreted, which is especially germane in the context of Bill C-9, given that as drafted now, C-9 provides a new definition of hate which has a lower threshold, which actually waters down the definition. And if you read the British Columbia Human Rights Tribunal decision, which came about the other day, you actually see how the tribunal has had to walk through in its process. This line meets the threshold for hate, and this line doesn't. This is hateful, this is discriminatory. And there's a lot in that decision that, again, I find very harmful to people's emotions and feelings. And I think there are things in there that I would never want to stand behind the substance of. But if you read the decision, it points to the problem of having to draw these lines. And this was, in the case of the tribunal, something where they could rely on Supreme Court jurisprudence, notably the Watcott decision, more recently the Ward decision, which actually try to deal with some of these balancing questions of whether a particular sentiment falls on one side of the hate boundary or the other. And in the case of human rights tribunals, they actually have a different definition they can lean on for things that fall under the threshold of hate, but still meet the threshold of what they view as discrimination. So it's very likely, because the criminal definition of hate is changing, that now some of these things that fell into a murkier territory in the BC Human Rights Tribunal decision would actually invite criminal charges. And we've now taken a bill that is, the Liberals claim, supposed to provide clarity and certainty, and have now injected more uncertainty, more ambiguity to it. When I talk to pastors and imams and rabbis and priests and leaders of Sikh gurdwaras and Hindu temples about this, the one unanimous sense that everyone could agree with was that faith leaders who act in good faith in this country do not wish to spread hate. They do not want a license to hate, because that is not what they know their faith to be. That is, they know their Bible, their Torah, their holy scriptures, their religious beliefs are not peddling hate. But they do not trust the government to draw that determination, especially in light of decisions we've seen made by human rights tribunals, and also in light of a lot of the discourse on social media right now, in light of Minister Miller's comments delineating scriptures as hateful. They do not trust the government or other bad actors in society who may wish to weaponize a complaints process to make those determinations. And all of them said, listen, our scriptures are about love. Our faith is about love. But we need the freedom to engage in this debate, the freedom to engage in this dialogue. And that is a freedom that they feel comforted by the existence of a specific religious defense on. And that's also how people will be able to root out the bad actors in society. You know, I pointed out in a number of these discussions, and it was unanimously understood, how there has been a lack of recognition by this particular government over the years on the tremendous benefits that faith communities provide to this country. Whether it's the church that runs the food bank to feed the homeless, whether it's the synagogue that runs the subsidized housing for seniors, whether it's the mosque that runs outreach programs for youth and children, all of these things. These are ministries, philanthropic initiatives that only exist because people of faith feel motivated to act out a message of love and faith and community that their religion tells them to do. And we don't get to benefit as a society from the good that faith communities do if we don't protect their actual right to spread their religious message and to share their religious teaching and to read their religious scripture without the fear that it will be weaponized against them. Legislating hate is legislating emotion. Calling verses of holy scriptures clearly hateful and inviting prosecutors to lay charges. Doing this can only erode religious freedoms. So for the government to say that there has been no effect of Bill C-9 on religious freedoms in the same breath as saying they are listening to concerns about religious freedom, and then provide an answer to that in the same breath as saying we'll address those concerns, saying that it won't actually change anything because you already have religious freedom, it's proving that the government is trying to check a box right now to solve a political problem instead of actually listening to these good faith concerns, which Ms. Latanzio, and I'm grateful she said, were sincerely expressed. And I'll even quote Mr. Housefather earlier. He said, "We do have to deal with the concerns that have now been raised as a result, and this for greater certainty clause, I think, will help do that." We have an admission that there are legitimate concerns. Concerns that, by the way, have been raised by Liberal members of Parliament. And I'm grateful for the leadership of some particular members of the Liberal caucus who have had town halls in their ridings to deal with these concerns and bring them back to Ottawa. I know that, Chair, you are also the chair of the caucus. I hope that you've been having a spirited discussion about this internally, and I hope that Liberal members of Parliament will be able to vote freely on this bill to deal with some of these concerns that are affecting communities in very different ways. This is not just about one particular faith community. Religious freedom, for one, is religious freedom for all. And political speech is just as affected by this as religious speech is. And I'd like to turn to the officials on this. You've had the opportunity to listen to listen to the wording of the amendment. I don't know if you have a hard copy in front of you, but does this amendment fundamentally change anything about what speech will be classed as willfully promoting hatred, specifically in a religious context, but in general as well?
So thank you for the question. What this for greater certainty clause would do would be to confirm the scope of conduct expression that is caught by the offences. It would not change the application of scope of the offences.
So does it change scope compared to what the existing or the previous religious defenses do?
So based on the as drafted, it would not. It would confirm again, the for greater certainty clauses are used to clarify, explain an existing rule or provision, or to clarify its interpretation. And this one focuses on the mens rea, so the mental fault requirement. And so this clause would make clear what expression is not captured by the offense as it currently stands. And so that is any expression. Sorry, just let me pull it up. It would make clear that, a person, nothing prevents a person from expressing on matters of public interest, and it gives examples of that. Nothing would prevent that from happening if they are not willfully promoting hatred against an identifiable group. And so this is serving to clarify the existing offense. Does that answer the question?
But it doesn't clarify what is captured by willfully promoting hate, which the existing religious defense does. The existing religious defense basically says that, good faith religious expression, as one example, is not willfully promoting hate. Whereas this has very circular language that it says willfully promoting hate does not include these things unless they're willfully promoting hate. So it's basically reaching its own conclusion by using the same language.
So the defense serves to clarify the scope of the offense. So to the extent that good faith expression is incongruent, the court has said, in the sense there's a redundancy with the offense, this clause would serve to confirm that indeed good faith expression, as was contemplated in the defense, that is not caught by the willful, it would not meet the standard, the high threshold of willfully promoting hatred against an identifiable group.
So if the last line of 11.11 and 11.12 were removed, so anything after publication or debate, which is basically what I would view as the circular line, if they do not willfully promote hatred against an identifiable group by communicating the statement, would removing that line strengthen the protection in your view?
Again, the purpose of a for greater certainty clause is not to add something new. It is to clarify an existing rule. So by removing that, I think the essence of the clarification, which is on the mens rea, would be removed from the clause.
Okay, so because it's not adding, if C9 did in fact weaken religious protections, this bill would not strengthen defenses against those, you're saying?
What I'm saying is the removal of the defense is a separate issue. This clause reinforces the narrow scope of the offense and what expression is captured by it, and addresses misunderstandings about perhaps the repeal does of the defense.
So I appreciate that, and I do not. My issue with this is not lying in what our officials who have been very patient throughout this process have been saying. I think the problem is that we're finding that stakeholders that engaged in dialogue with members of the Liberal government have been told something which is different from what's actually been moved. They were told that they would hear these concerns, put robust protections in the bill that ensure religious freedoms will be upheld. That the Mark Miller fantasy of going to arrest people for Bible verses they quote would not actually live out in this. And what we're being told, quite frankly, through this is tantamount to gaslighting. that there is no reason to be alarmed. And I would note that the government has still not decided or has not publicly signaled whether it will be appealing the Federal Court of Appeal decision on the Emergencies Act. This was the decision that found that the government broke the most supreme law of the land, the Constitution, when it, just over 4 years ago, invoked the Emergencies Act to freeze bank accounts of political protesters, to limit the legal right to protest. And Minister Fraser, I asked him on committee, I asked in the House of Commons as well, and Minister McKinnon did not answer. But he has not said whether he will appeal this or accept this finding. And why I think that is so relevant is because that was also a situation in which the government used the very same circular reasoning here to defend its actions. They said when they invoked the Emergencies Act, this will not violate your charter rights because the charter protects your rights. And now the federal court and the Federal Court of Appeal have said that was a load of hooey. I think hooey is a parliamentary word. And here we have the same logic. Your rights will be protected because the charter protects your rights. Well, the charter may provide a remedy after the fact. If someone is charged, perhaps the charter will be invoked in what happened in British Columbia. But this government has not earned or warranted the benefit of the doubt when it comes to matters of conscience, when it comes to matters of faith. I mentioned earlier the tremendous work that faith institutions do across the country, including in my riding, and I'd be remiss to not point out that that was put in jeopardy some years back when the Canada Summer Jobs Program was risked by a government amendment, a Liberal government amendment, that forced faith organizations and other organizations to basically forswear certain deeply held religious convictions to get a little bit of help to hire a summer student. We had the recommendation from Liberal and New Democrat members of the Finance Committee in 2024 that was going to remove charitable status from houses of worship. All of that pales in comparison to laws that will threaten prosecution, that will chill freedom of expression and religious freedom for deeply held religious beliefs, which are not protected by this amendment. And we've heard from the government, we've heard from Ms. Latanzio, we have heard from the departmental officials that nothing in this proposed amendment actually strengthens protections. It merely reinforces the status quo. So if the status quo is what's causing people to be concerned, the government's own admission is that there is nothing in this that will address those concerns. So at this time, Chair, I would like to move a sub-amendment, which is that everything after publication or debate in 11.11 be deleted, and everything after publication or debate in 11.12 be deleted.
Do you have that in writing?
No. I can put it in writing if you'd like to suspend or...
Yeah, let's suspend for a moment. Mr. Lawton, you still have the floor.
Yeah, so just to provide some context on this sub-amendment, I think that currently this certainty/clarification clause has actually created more uncertainty. The question I have is whether the Liberals actually want to protect religious freedom and freedom of expression and acknowledge truly that these sincerely expressed concerns with this bill are because of what's in the bill, are because of what the bill actually does. So I'm trying to, with my sub-amendment, at the very least, eliminate the circular and, quite frankly, confusing language by indicating that it is not willfully promoting hate if you are expressing a matter in the public interest, including an educational, religious, political, or scientific statement. Because to say that it's not willfully promoting hate if you're doing that, unless it's willfully promoting hate, is incredibly illogical on its face, because it doesn't actually help us articulate whether a deeply held good faith religious view can be misconstrued by the state as willfully promoting hate, whether a political statement does. And again, this is in context, an issue in which the government has a track record of limiting good faith political expression and dialogue. So we cannot be told that the status quo protects these freedoms when it's clear the status quo doesn't protect these freedoms. What we need, if we're to have a bill that truly protects Canadians from this overzealousness by the state, including the very Canadians that Bill C-9 purports to protect, Canadians of faith and minority communities, we need to be able to strengthen protections, provide robust protections, not simply say, don't worry, you have these freedoms because the Charter says you have these freedoms. So I would very much I see Mr. Housefather's hand is up. I would very much appreciate any clarification from my Liberal colleagues when they intervene on this about whether they are serious about addressing these concerns rather than just pacifying this political problem. Because I had calls from faith leaders this morning and representatives of a range of groups, again, representing Christian leaders, Muslim leaders this morning, and what they said they were told was coming is not what's in this amendment. They were told there would actually be a reckoning that removing the religious defense created a problem, and the government was hopefully in good faith going to help solve that problem. Instead, the language that's been put forward is meant to tell people there wasn't actually a problem in the first place, don't worry. And the testimony we heard from our very skilled and knowledgeable experts was that this does not change anything. This maintains the status quo. So this is not actually an amendment at all. And if this were to be removed, everything in the bill would remain the same. So if we're actually trying to deal with these concerns head on, this is not the way to do it. Thank you.
Thank you. I have Mr. Next.
How much time do I have, Mr. Chair?
About 3 minutes.
Point of order, Mr. Chair.
Sorry, who's Mr. Housefather?
Yeah, point of order, Mr. Chair. I'm sorry. I think you've allowed Mr. Lawton to speak to a sub-amendment that he raised. I don't believe this sub-amendment is in order, Mr. Chair. This sub-amendment would completely negate the intention of what the proposed amendment does and says, and it would completely change how the criminal code interprets what is or is not hate speech. And willfully promoting hatred against an identifiable group. This would essentially say anything at that point, as long as it is communicating a statement on a matter of public interest. It does not constitute willful promotion of hatred. It would completely negate the criminal code. It's against the purpose of the bill. So I didn't know when to intervene, Mr. Chair, because you kept letting him speak. So have you made a ruling? Because my argument is this is completely not in order.
Mr. Housefather, I haven't seen the amendment in writing in a hard copy myself. I've seen it circulated on email. So, Mr. Baber, do you have a comment on the same point of order?
Yeah.
Okay.
So Mr. Lawton's sub-amendment seeks to only delete a portion of Ms. Latanzio's amendment. Just because it has a different legal effect, as it may, according to both Mr. Lawton and Mr. Housefather, does not make it out of order. the substantive change that would be triggered by Mr. Lawton's sub-amendment is still within the scope of this section. But a motion that seeks to, a sub-amendment that seeks to delete, to only delete a portion of Ms. Latanzio's amendment would certainly be in order, irrespective of the legal effect.
You stopped talking. Does that mean you're done?
Yes, I'm done.
Okay, thank you. Okay, just one moment, please. I've had two people talking to me at the same time. Look, here's what I'm going to do. It's 1 o'clock right now. I need to see a hard copy of this amendment before I make a ruling. So I'm going to adjourn the meeting, and we'll see you on Wednesday.